Very interesting topic, and it has become more important because of the Supreme Court judgments in the past 2 years. Give this heading right down. Enforcement Directorate and Supreme Court judgments. Enforcement Directorate and Supreme Court, right? Supreme Court has changed the framework actually of the very stringent statutory provisions of the Prevention of Money Laundering Act 2002. In 2002, it upheld the powers that ED has. But in the past 1.5 years, they've changed the entire framework. That is what I want to discuss with you. First things first, when I say ED, when I say Supreme Court judgments, what is the thought? When you read ED or you read any Supreme Court judgment like today, Section 6A, first thing is what is the thought? Now, importance for the examination, it's a core GS paper 2 polity topic. And regarding the thought, the perspective, I have ED, which is an investigative body, we'll discuss it. And there are several bodies which are asked in the civil services mains. Like they've asked CBI. Like they've asked NIA. Like they can ask NHRC. Like they've asked CCI, Competition Commission of India. And like they might ask a body which is in news for the good reasons because of a very interesting and a very activist chairman of this body, again an IS officer. It is called as Central Consumer Protection Authority. It had fined the coaching institutes that they were misleading the students. Remember? These bodies are asked in Civil Services, General Studies Paper 2. They can be asked in the format of a regulatory body, or they can generally want you to analyze the role. So how to analyze this? We'll draw a structure. That's common for all of them. That is how you need to perceive them. And when they increase the misuse, then we got the power of review. Who does it? The Supreme Court. The Supreme Court does a review. And when Supreme Court does a review by giving a judgment, you need to look at that judgment from a larger perspective. In the exam, when they ask Supreme Court judgments in GS paper 2, they pick up a theme around that topic. बड़ी rarely पूछेगा, क्योंकि ये तो बहुत बड़ी judgment है और couple of judgments हैं, ये सीधा पूछेगा. But in the larger themes that we have, they'll ask you on gender justice, Supreme Court judgments. They'll ask on environment. They'll ask on Article 14. They'll ask on Article 21. They'll ask on cooperative federalism. जैसे 370's abrogation was upheld in December. For example, recent judgment regarding the sharing of taxation revenues. The states have got the power to levy a tax. We'll discuss it. But that has to be seen under the larger lens of Supreme Court's role in cooperative federalism. Or I can also say the vulnerable sections. It could not be a better example than the recent judgment. Regarding what? Regarding what? Regarding what? Regarding denotification of what? No, something major. Child pornography. Yes, CSEAM. Child sexual exploitative abuse material. We'll not call it pornography. That's a derogatory term. It's a larger, because pornography can be out of will also. And that is not will, it is exploitation. So एक broad perspective में वो आपसे जजमेंट पूछेगा सुप्रीम कोर्ट की, ठीक है? तो ये दो टॉपिक्स का थॉट है. इस केस में हम जजमेंट डिस्कस करेंगे. कोई भी सुप्रीम कोर्ट जैसे आज आई है तो आपको सोचना उसको वैसे ही है कि किन किन बातों में सुप्रीम कोर्ट ने ऐसी जजमेंट्स पहले दी हैं. जैसे 2018 में पूछा, 21 में पूछा, सुप्रीम कोर्ट जजमेंट रिगार्डिंग एनसीटी ऑफ दिल्ली, द डिस्प्यूट बिटवीन एलजी एंड द सीएम. So that relates to cooperative federalism. Is it clear? Now let's draw a structure here only. And I would want you to keep this entire page free. I'll use a different page, but the first page of your notes will always be free, because you need to revise and add the keywords in the structure. वो आपका काम है, क्योंकि हर व्यक्ति कक्षा में कुछ ना कुछ अलग अलग याद करेगा, भूलेगा. तो आपको अपने हिसाब से अपना एक सिनॉप्सिस एक पेज का बनाना है. उसकी फोटोकॉपी करा के आपके पास 70-80 पेजेस हो जाएंगे. मतलब इतना तो बहुत बड़ा है, ये तो 7-8 हज़ार है. इतने जो आप मेन से पहले याद करोगे, याद बस ऐसे टर्न करोगे, इट विल देयर इन योर हेड. आर यू ट्राइंग टू अंडरस्टैंड माय पॉइंट? नाउ लेट्स राइट डाउन द स्ट्रक्चर. Structure first is very simple. What is ED? Second, I find is very interesting. I'd like to ask you. It's too much in news, so you got to tell me. ED versus police. सेम नहीं है. यही सबसे अच्छा पार्ट यही है. जजमेंट्स भी थोड़ी ट्रिकी हैं, पर ये मुझे सबसे मुश्किल लगा समझना. इसको पढ़ाने से पहले मुझे भी इसकी जानकारी नहीं थी, तो हम इसको डिस्कस करेंगे. देन वील डू व्हाट? आई वुड लाइक टू डिस्कस द रोल ऑफ ईडी अंडर व्हाट? प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट एंड पावर्स ऑफ ईडी. And powers of ED. Structure should be clear, right? And you look at this. I told you, right? Supreme Court comes in the picture. So these powers of ED are by the law. Supreme Court set the house in order. तो यहां पे ED को रोका, जो हम डिस्कस करेंगे. So we'll write here recent Supreme Court judgments. Is it clear? And then I'll write down what? Analysis of ED as a body. Means where it has done good, where it has done bad, and then finally, in the end, we'll write a way forward. इसमें मैं आपसे ये नहीं पूछूंगा गिव सजेशंस. ये पॉलिटी का टॉपिक है. You cannot expand. In polity, when they ask you, do you agree? Don't get emotional. मेरे को तो ऐसा चाहिए. Polity में you always give suggestions which are either given by the court or there is some commission which has gone into the inquiry of that particular matter and you want to know that. That is your strict. Polity is the easiest to understand. Is it clear? Let's start with ED quickly. First is very simple, basic points we'd like to write. What is ED? Now let's start the first thing. Quickly tell me, what is ED? Online ones. Very simple. You know much more than me. What is ED? What is ED? ED is what? ED is investigative body. Number one. And multidisciplinary organization, investigative body, all of you know, and multidisciplines, different types of crimes they will investigate. When you say investigative body, investigates what? Investigates what? Number one, economic offenses. Money is involved. Money has to be there. I'll give you a keyword. Paisa or offense. That is economic offenses. And what? Forex laws. Foreign exchange laws. I earn money and I transfer in US. Hide that money, something like that. Foreign exchange laws. So I'll discuss, just to give you a broad framework. Give me the name of the laws. What are the laws? Very good. First is FEMA, Foreign Exchange Management Act. All of you know that. Foreign Exchange Management Act plus, ये तो सभी को पता है, Prevention of Money Laundering Act. I hope my pace is fine. Online students, my pace is fine. Okay. Then Fugitive Economic Offenders Act 2018. You've committed an offense in my country. You become Vijay Madanlal, Nirav Modi, Mehul Choksi and run away. How will the court find you? So we got a law for you. Fugitive Economic Offenders Act will attach your property. अपने आप इंडिया में आएगा. Because it's very interesting. I'll just tell you, I'm leading you slowly towards ED versus police. What else? Two more laws, not very important, but for your prelims, it is FERA, Foreign Exchange Regulation Act 1973. No, not FCRA. Be careful. FCRA is Foreign Contribution Regulation Act, Ministry of Home. That is Ministry of Home. Income Tax Ministry of Finance goes there. These are primary laws. FERA has been repealed. Yes, you're right. But till 2002, the pending cases, if there were any, they would have been dealt with the ED. So we still write it. You're right, it has been repealed. पर कोई पुराना केस था, because 2002 में मनी लॉन्ड्रिंग एक्ट आया और 2005 में इसको हमने मनी लॉन्ड्रिंग के तहत इसको इम्प्लीमेंट किया. तो कुछ पिछले केसेस थे, उसके लिए हमने फेरा का लेजिस्लेटिव डोमेन वी हैड केप्ट इट, व्हिच इज टेक्निकली कॉल्ड एज लेगेसी केसेस, एंड देन इट इज कॉल्ड एज कॉफी पोसा. Coffee Posa 1974. Have you heard this law? Coffee Posa, COFEPOSA 1974. What is Coffee Posa? Write down conservation of foreign exchange and Prevention of Smuggling Act. And Prevention of Smuggling Act. These 5 laws we had, and one more point I'd like to write. We can write that it functions under what? Department of Revenue. Under Ministry of Finance. Department of Revenue under Ministry of Finance. And one more thing, if I go into the past, entire history is not important. It was actually 1956 when we established Enforcement Unit. We made this body Enforcement Unit. In 1957, we rechristened it. We gave it the new name that we all know as Enforcement Directorate. Prelims related information, which of the following laws, which ministry, which department, something like that. So you told me FCRA, I said no. Is it fine? Now, something interesting which I'll use later when I discuss the role of ED. This is important because the director of ED is appointed by the government on the recommendation of a committee. I'd use it later. Just know who are the committee members. You want to guess? ED's director is an IRS officer, by the way. So these committee members is Chief Vigilance Commissioner, 1. Vigilance Commissioners, how many we have? No, not 5. 2 or less than 2. Then Secretary, the highest civil servant of that ministry, Secretary Home, Secretary Department of Revenue, and Secretary Ministry of Personnel. They will recommend what? They will recommend the candidate to the Government of India. They will recommend the candidate to the Government of India. Yes, same committee chooses CBI director. What is the source? Is there any ED Act? There is NIA Act for NIA. There is no CBI Act. There is no ED Act. But this information which I am sharing with you, it is given in the CVC Act 2003. Central Vigilance Commission Act 2003. So appointment of ED director is as per the CVC Act. And there is a catch here. Year is 2021, and that actually opened a can of worms. The can was already opened, but the lid was stripped off with this step which I'll discuss in the end. In 2021, in continuation to this discussion, there was an amendment, Sanshodhan, that did what? That did what? The term of ED director is not less than 2 years. Not less than 2 years. So we used to appoint directors for 2 years because that is what the law permits. It's not less than 2 years. It is not less than, it is not more than 2 years. Do se kam nahi, it is not less than 2 years. Which means kam se kam 2 saal, but we used to appoint for 2 years. We changed this. We said, if the government wants, we can make it how many years? How many years? 5 years. I'll discuss it again, and this is how 1 year at a time, which means one year at a time. One year at a time means what? 2 to 3, 3 to 4, 4 to 5. There cannot be a blanket order that will make it straight. ED director appointed for 5 years. No. Appoint him for 2 years. Law said extended by 1 year. 3. You want further extension? 3 to 4, 4 to 5, and there's a full stop. Beyond 5 years, it is illegal. And this was against a Supreme Court judgment spirit, which I'll discuss later. Is it clear? This is the gist of ED for your prelims. What is ED? Second point. Second part, write down ED versus police. Now, this is what I want you to tell me. Online students also can participate. यही है जिस्ट. एग्जाम में पूछेगा नहीं, पर काफी इंटरेस्टिंग है ये. बताइए. हाँ, वो तो है सेंटर स्टेट मुद्दे की बात. बिल्कुल सही, क्या वो भी बताएंगे. प्रवर्तन निदेशालय और राज्य पुलिस में क्या अंतर है? हाँ, वाई? No. And when will ED come into picture? So, if you don't pay the fees and you run away, I'll file FIR against you. Then police will say what? Law and order, no. Okay, I'll tell you. Listen to me. IRS and ED are central service. No. Center state, it's okay. I'll discuss that. Okay, now listen to me carefully. This individual commits a crime. इसने एक crime किया. Crime मतलब so many laws are there. Prevention of Corruption Act. There's entire Bharatiya Nyaya Sahita. There is Motor Vehicle Act. There are so many laws that we have. Primarily, all these criminal offenses, they'd be investigated by the police. I hope all of you know this. So there's a person, he is accused of a crime. Crime comes into picture, and thereby I'm automatically saying the police does what? Registers FIR. Which you all know, I hope. Police is state subject, law and order, public order, state subject. Give me some crimes that you know. Some crimes that you know as a citizen, all of you. Online ones. Crime बताइए तो simple. Murder, बिल्कुल, murder. और theft, बिल्कुल. मोबाइल फोन बहुत चोरी होते हैं मेट्रो स्टेशन के बाहर, ध्यान रखिए. Harassment, बिल्कुल. I'll write sexual assault. That is, I hope you understand. और बताइए. I'll write simple. Yes, बिल्कुल. डरा दिया, इतने भारी भारी भी नहीं बोल रहे. ये क्राइम है, ठीक है. सारे क्राइम्स में इन्वेस्टिगेट करेगी पुलिस. विक्टिम में FIR दर्ज करेगा, FIR shall be filed, और पुलिस comes into action. Now I'd like to add something which makes it very interesting. Crime happened. and there are proceeds of crime. What is proceeds of crime? एक तो यार भाई करंट अफेयर्स क्लास चल रही है एंड ब्रेक ही नहीं दे रहा टीचर, गुस्सा आया, जैसे ही टीचर बाहर गया, गुस्से में आजकल तो कुछ भी हो सकता है, युवा वैसे ही गुस्से में आक्रोश में रहते हैं, निकाला चक्कू भोंक दिया मेरे को भी और इन दोनों को भी, यह तीनों गए, क्या होगा? पुलिस विल इन्वेस्टिगेट and you will be in the prison. You committed a crime, you murdered me. That is one thing. ठीक है? Another thing, somebody tells you that, you know, I've got animosity with this teacher, let me pay you some money, let's say 10 crores, and you kill this person. For all these crimes, you steal something, I steal something, let's say out of a bank, rupees 10 lakhs. Police comes, arrest me for theft. कहाँ है 10 लाख रुपए? ये रहे. Okay, that's okay. You kill me with your aggression, that's okay. When you kill me for money, that is your proceed of crime. You've committed crime. Police has come into play, but that proceed of crime, that 10 lakh theft, that money that you've taken to kill me, if you go for laundering of that money, you take that money and you organize a theft, any of the two, that money is earned, proceed of crime, and you send it to a different person. When police investigates you for the crime, they understand that the money was involved, but what to do? What to do? Police will investigate you, file a charge sheet, मर्डर की धारा लगी, पनिशमेंट मिली, वो 10 लाख रुपए, थेफ्ट तो दो साल में बाहर आ जाएगा, वो 10 लाख रुपए क्या करेगा उसका, वो कहां गए? That was the need of this law, Prevention of Money Laundering Act, which felt that there were criminal offenses which were listed already in laws, listed in IPC, like drug trafficking, Narcotics, Drugs and Psychotropic Substances Act. There is 100 crore cocaine getting confiscated by the police. But where is that money? Police cannot trace it. FIR registered, convicted, and in 3 years, that person is released. So thereby ED was given the power to look for proceeds of the crime. The crime which generated proceeds could be money, could be property, tangible or intangible, where ED's role thereby comes after the crime has taken place. That crime has proceeds of crime generated and it is untraceable. If 10 lakhs stolen from the bank is found by the police, what is the need of ED? 10 लाख चुराए और 10 लाख रख दिए, ये नहीं कह सकते ना, नहीं अब तो 20 लाख दे. No, proceeds of crime were generated, but the police located it. If the police cannot do it, we gave the powers to ED to trace the proceeds of the crime and thereby allow ED to attach the property. Where police does not have the power to attach the property, but ED was given the power where even if the crime got committed and the person was given the punishment, but he generated dirty money, he generated that money which was by illicit measures, he laundered that, he had transferred that money to somewhere else that could not be traced. That is where ED comes into play. And if ED thinks that the trail of money has not been located and you are involved in proceeds of crime, they immediately attach your property. And there's a procedure in the law by which the jurisdiction of different authorities ensure that in case if you're not involved, they'll return you, but your property will be with the government of India. Big chunk of money. Do you understand? And that is why if I tell you now, police versus ED versus CBI versus NIA. What does police do? Investigate the crime. What does ED do? Trace proceeds of crime. So for ED to come, there has to be a crime. First, there will be crime. If there are proceeds of crime, then there is ED. If there are no proceeds of crime, then there is nothing called as ED in the picture. CBI is for crime. Police is for all the crimes. CBI is for the crimes which the states could not investigate, any offense. If the state government wants any offense under the sun, they can give it to CBI. Best example, the unfortunate incident that we'd seen in Kolkata. The state police was incapable. They said that you please let the CBI investigate. So CBI comes, either the court tells CBI to investigate or the state says please go ahead and do it. And NIA investigates again the crime. Which crime? Which are terrorism related. I hope you're understanding my points. Which are terrorism related and many more. Main terrorism. They will also do what? File a case. But ED will come after the crime has got committed. Right? Then you said that center state, very simple. Police works under state. ED works under center. Department of Revenue, CBI works under state. Center, where? No. Department of Personnel and Training, and NIA works under? Good. Center, first tell me center, Ministry of Home. Is it clear? Is it clear? Next is what? Consent. Consent, permission. For police, obviously, consent किसका चाहिए? Center का. State. Law and order, state subject. Consent of state is required. For ED, what is the consent? Is it required? Consent of state is not required. CBI, very good. Consent is required, not required? Required. CBI is not FBI. What is FBI? Federal Bureau of Investigation. It's a CBI of US. You must have seen in the movies, no? FBI agents. तहकीकात करने आए हैं, अगर हिंदी translation देखें तो. So they do not need the permission of states, 50 states in US. CBI needs, asked in the examination 2 years back. States are not giving consent, ruled by opposition. So we say CBI is a possible services means. Caged parrot. पिंजरे में बंद तोते के समान है. Typical question. Asked in the mains. That same structure like ED will apply for CBI and NIA. Consent required or not? No consent. It's the FBI, but for terrorist offenses only. Limited scope. Consent not required. Consent means permission of the state. And now if I just discuss police and ED, further division is not required. If I discuss police versus ED, police registers FIR. Crime happens, register FIR. Crime हुआ या नहीं हुआ, पहले FIR करो. The bar is very low. When police registers FIR, though they don't register, but वो जो करेंगे ही नहीं, मोबाइल फोन चोरी हुआ, अरे ऐसे कैसे हो गया, आप भूल गए होगे मेरा भी चोरी होता है, वो करेंगे नहीं. पर लॉ वाइज इट्स वेरी इजी, द बार इज वेरी लो, बट फॉर ईडी टू अरेस्ट अ पर्सन द बार इज वेरी हाई. दैट्स द नेक्स्ट पार्ट. ईडी का अरेस्ट करना बहुत मुश्किल है, पुलिस का अरेस्ट करना आसान है, और पुलिस के चंगुल से छूटना भी आसान है. अंडरस्टूड? The bar to get arrested by police is low, and thereby is the bar to get a bail. Bar under ED to get arrested is very high, and so is the case of getting a bail. Ek bar you go inside, you will not come out. Now you can come out because Supreme Court has given many decisions. That's the second part. So, police registers FIR, ED registers ECIR. What is ECIR? Enforcement Case Information Report. I'll discuss it. And I'll tell you something. FIR is legal. What is legal? Legal. It is backed up by law. And that's the catch which we'll open up. The ECIR, which is fined by ED, is it legal? I will not say it is illegal, but it is not legal. Because there is no law that says ED can register ECIR. It's an internal process of ED. That's what they have evolved, which I'll use later. समझ में आ रहा है? And then comes the last point, which is dangerous. It was asked in prelims. There's nothing called as pre-oriented current affairs. They are, but very few. They're very simple. And if they are tough, then they are so tough that you cannot attempt them. They are meant to be left. Is it clear? This came up in the prelims 2 years back, 2023, that the confession before police admissible in the court of law? Admissible? No. पर यहाँ पे it is the only law in the country where confession before ED is admissible. Came up in the exam. Came up in prelims. And I tell you one more thing. This provision was there for UAPA. This provision is there for this two laws. They are the heights of being draconian. First is Prevention of Terrorism Act 2002. It got repealed. Draconian, important, what to do? 2001 attacks the parliament, December. We needed a law. And 1991, Tada, Sanjay Dutt got arrested. Both of them, the police was coercing, the person, bata, tune kiya hai, torture, kiya hai, haan maine kiya hai. And then the person used to get convicted. इसमें टॉर्चर नहीं कर सकते. दीज आर इकोनॉमिक ऑफेंसेस, वाइट कॉलर ऑफेंसेस. पढ़े लिखे लोग आपके मेरे जैसे क्रिप्टो ट्रेडिंग करेंगे, इनसाइडर करेंगे, यहाँ का वहां करेंगे, तो इसका नेचर अलग है. देयर इज नो टॉर्चर दैट इज इन्वॉल्व्ड, बट देयर इज अ प्रॉब्लम ऑफ प्रोलॉन्ग्ड इनकार्सरेशन. एक बार अरेस्ट तो कभी नहीं छूट सकता. 7 साल की सजा है, वो खत्म हो जाएगी, तब छूट जाओगे आप, और आपका ट्रायल कभी भी फिनिश नहीं होगा, बेल नहीं मिलेगी आपको. दैट्स द पॉइंट वी वांट टू ओपन अप नाउ. Is it clear, all of you? Now let's come to what? What's the next thing? Let's come to the legal part. PMLA and ED. So I'll first give you a brief of PMLA and then I'll discuss the role of ED. So we can write down PMLA and ED. PMLA and ED. Thank you. PMLA, you know the history? The background is very interesting actually. This background, just know a bit. The background actually was 3 events that we saw. First was in 1988. There was a UN convention for what? In 1988, we had a UN convention against illicit drug trafficking and narcotics. You know the name of this convention? This UN Convention against illicit drugs and narcotics. What was the name of this convention? This is popularly called as, I'll write it here. Okay. This is called as Vienna Convention. It led to what? Just to inform you, it led to anyone? Prelims. International organizations will take. It led to formation of, starts with the F. FAO. What is F? FATF. Financial Action Task Force. And they established their headquarters where? In Paris. It is not a UN body. Be careful. In IR, they ask you, we'll discuss in the class, though, it is not a UN body. It is intergovernmental body. Government are members. Headquarters in Paris. OECD's Organization of Developments, has got headquarters in Paris. That is what they use as office. Is it clear? So this was Vienna Convention. It is actually the first convention against drugs. First in the world. And US has got a very important role to play. And India got the NDPS law in 1985, ahead of the global this thing. Is it fine? And then we had two resolutions that came up in 1990 and in 1998. This is UNGA resolution. 1991 was more important. And under these UNGA resolutions to address money laundering, finally India passed what? Finally India passed what? India passed what? Yes, obviously. India finally passed what? Prevention of Money Laundering Act 2002. PMLA 2002, it was passed in 2002. It got enacted in 2005. UPA government had framed rules in 2005. That is when we started implementing it. So Mr. Vajpayee brought it, but implementation began with the UPA one, Congress government led by Mr. Manmohan Singh. Right? Let's get to see the provisions now. Should I go ahead? Right. So provisions are, first, it relates to what? Proceeds of crime. It has to be proceed. A proceed is a must. Which crime? Every crime under the sun? Which types of crime? Economic is open-ended. Crimes listed in this law. And these crimes listed in the law, they are given in the end. We call them as scheduled or predicate offenses. Scheduled offenses. In fact, we had just 6. Initially. And the government is trying to amend this law. It has done it quite a couple of times. And you look at this. The number of predicate offenses has increased from 6 to 30. Initially, it was for money laundering, drug trafficking. But now for criminal conspiracy, corruption, Copyright Act, wildlife trafficking. More than 30 laws are now covered. Humongous powers given to ED. And that's a concern because you are trampling over the powers of the state. The first hint, federalism is coming in the perspective. यही पूछेगा, फेडरलिज्म, जहां सेंटर ने लॉ बनाया पब्लिक ऑर्डर या क्राइम के लिए, फर्स्ट क्वेश्चन ही फेडरलिज्म है, which you need to discuss. Second, punishment. How many years? 3 to 7 years. 3 से 7 साल कम नहीं है. Is it too less? या ठीक है? कैसा लग रहा है ठीक? मतलब अंदर से फीलिंग आ रही है ठीक है? ठीक मतलब 7 काफी है, मतलब 1 2 3 टाइप, 7 साल तो कोई भी रह सकता है. क्यों है? कम है, ज्यादा है? ज्यादा क्यों नहीं है? मैं तो सोच रहा था मनी लॉन्ड्रिंग, सुप्रीम कोर्ट ने कहा विजय मदनलाल केस में इट्स लाइक ऑफेंस इक्विवेलेंट टू टेररिज्म. टेररिज्म तो सजाए मौत है. लॉ कमीशन कहता है टेररिस्ट ऑफेंस है, टांग दो उसको. सोचो मत, EU वाली बातें मत करो, नहीं डेथ पेनल्टी नहीं देंगे, राइट्स है, ना ना ना, तुरंत हैंग दैट पर्सन. 3 से 7 साल क्यों है? और 10 साल मिल सकती है आपको अगर आप, इफ यू आर गेटिंग कॉन्विक्टेड फॉर द प्रेडिकेट ऑफेंस ऑफ NDPS 85. क्यों है 7 साल, मुझे ये बताइए. वैसे पूछेगा नहीं, पर वैसे 100% क्लैरिटी क्या आपको होना चाहिए, लॉ की क्लैरिटी बताओ. एक्चुअली ना ये दिस इज अबाउट व्हाट, this is about what? Is it about crime? It is about what? Proceeds of crime. This is dangerous. Murder is dangerous. Assault is dangerous. You might get death penalty also, let's say for a child sexual assault or a gang rape. But we are not discussing crime. We are discussing punishment because of proceeds of the crime getting laundered. You might think that, am I not punishing the same person twice? Is it not against the Constitution? Double jeopardy? Article 20? What do you guys think? Am I not punishing the same person twice? No. Committing a crime is one thing. Those proceeds of crime being laundered, that dirty money getting laundered for a separate purpose is another. So this 3 to 7 years I'm telling you is for proceeds of the crime getting laundered. And both of them are separate. If you remember, when Mr. Kejriwal was released by ED on bail, was he out? No, because he was arrested by CBI for the crime of corruption. He got released only when the CBI court gave him a bail. He was involved. Yes, because corruption is one of the predicate offenses for which proceeds can be investigated by the ED. Do you understand the point? Do you understand the point, all of you? Is it clear? Now let's go ahead. Provision is, and now let's write down the powers of ED. This is what is very interesting. Third is powers of ED. In case of powers of ED, the first thing that we'll write will be what? What is the first thing that we'll write? First is ED has got the powers to investigate. That's the first thing. I hope there's no problem. Second thing is it can attach the property. I hope again you know this. I have discussed it. In India and abroad, it has got the power to search, survey and seize. सर्च सर्वे एंड सीजर, सर्वे किया एरिया का, उसकी छानबीन करी और सीज किया, राइट. इट हैज गॉट द पावर्स टू समन, it has got the powers to summon, and when it summons, it has got the powers of a civil court. When it is summoning a person for investigation, your person has to be there. Any doubts? Attached properties means that, a person was accused of a crime. He got proceeds of crime, let's say 10 crore, and we cannot be sure it's under investigation. So this Money Laundering Act allows ED that you attach his property. There's a procedure. Whether he is involved or not, that's a separate thing. But you are allowed to attach at the very start with the permission of a tribunal. That's not required. And then the proceedings will go. If you're acquitted, then your property gets returned back to you.
Attach means they basically
Under the control of the central government. In what? Yes, it was by 2018 amendment. Whether they get access or not, that's a different thing. Example is Mr. Vijay Madanlal's house. It's not house. It's a villa in, from what I remember, Milan in Italy. That was attached because ED has got the powers to attach assets abroad with obviously the close relationship with that country. That is, wo to hai, that's a different thing. Till the point the court settles it, they cannot. They will be confiscated. If the court is given, if it is proven by the court of law, then they can monetize. Like Nirav Modi's cars in Bombay, they were sold off because he got proved in the court of law. Here, should I go ahead? Right? And then comes the most important part. So then is what focus here? Section 19. What is section 19? You need to remember it. It's the power to arrest. And the bar, you feel it. The clause is giving you, the bar is very high. I'm writing in bracket for your thought. It's very high. Yes. PMLA only we are discussing. That's the main law. See this. Write down. Write the way I write. ED can arrest. ED can arrest if based on material in possession. These notes are material in possession. Your mobile phone is a material in your possession. This laptop, this screen, this stylus is a material in my possession. So if you've got some material in possession, again, ED can arrest if because of material in possession, ED has reasons to believe. Material in possession leads to reasons to believe that the accused is guilty of offense. Guilty of offense. arrests the person. Material in possession leading to reasons to believe that the person is guilty of offense. And if comes arrest, after that comes what? ED is arresting Mr. Sisodia, Satyendra Jain, Mr. Kejriwal. Then bail. High bar for arrest, automatically high bar for bail. Police, low bar for arrest, automatically low bar for bail. And this is another section you got to by heart because you need to write them in the examination. Section 45, which is bail. First things first, reverse burden of proof. ED will not justify, you will justify. Accused is innocent until proven guilty. I know that. You are not guilty. You are accused. But mind you, you are under arrest. You are in incarceration. आप अभी अभियोगी हैं, मुजरिम नहीं. पर सवाल अभियोगी और मुजरिम का नहीं है. It is not a question of the fact that whether you're accused or convicted. That is the cardinal principle of law. But I'm discussing bail. So, if you get arrested, you want bail. You will need to prove, and then the law says, number one, the court, one more minute, the court would listen to public prosecutor. Who is public prosecutor? Public prosecutor. Have you heard this term? Yes. The lawyer for ED, Sarkari Vakil. When a crime is happening, police will, I commit a crime, I'll get a defense lawyer. Police will do what? CBI will do what? NIA will do what? Hire a public prosecutor who will ensure that the person that has been arrested, he gets the punishment. Prosecutor तो बोलेगा ही नहीं छोड़ो, पूरा लॉ पढ़ा देंगे, ऐसा ही होता था. लॉ अपने आप कह रहा है रिवर्स बर्डन ऑफ प्रूफ. कौन सा जज? Why would a judge take the headache? The law itself is draconian. So it was impossible. Number one, at the outset it became impossible, and then we have twin condition of bail. Actually कहीं जगह twin बोलते हैं, कहीं जगह 3 बोलते हैं. Twin condition of difference between normal burden of, normally the state has to prove that you are guilty. It's your right to bail. Police has to prove that you are guilty. यहाँ पे उल्टा है. I need to prove as an accused that I'm guilty. Is it clear, Aditya Agarwal? Twin conditions. Number one, twin conditions of bail. What will court satisfy? The court will satisfy that accused, or you write like this, the court has reasons to believe. One minute. The court has reasons to believe. ऐसे कारण कोर्ट को लग रहा है, ये हमें पता नहीं है, अभी कॉन्विक्ट चल रहा है सेंटेंस, पर हम बेल की बात कर रहे हैं. Try to understand. Don't think अरे convicted rule change कर दिया. No. Release on bail. Reasons to believe that the accused is not guilty. Just 1 minute. Accused is not guilty. And number 2, will not commit a crime during bail. एक तो भाई कोर्ट को, जज को लगना चाहिए. अब देखिए जज को लगना चाहिए. पब्लिक प्रोसिक्यूटर को सुन लिया, and then he needs to think that, okay, I think he's not accused, in my opinion. Let the trial go on. But there's no need to keep him behind the bars. Release him. And number two, it is also sure if I release on bail Mr. Kejriwal, Sisodia, Satyendra Jain, they will not commit any offense. Is it fine? Just give me 1 minute. Is it fine? And regarding the syllabus completion, I got a mail, 2 mails I got, sir, how will the syllabus get completed? You should not worry about that. That's my headache. I will plan extra classes. I have told in the video, that demo video, that I'll plan extra classes. That's my headache. I'll plan it in such a manner that your preparation will not burdened. ऐसा नहीं होगा कि मैं प्रीलिम से पहले आपको 1.5 महीना पहले धड़ाधड़ क्लास ले रहा हूँ या मेन से पहले ले रहा हूँ. मैं प्लान जैसे करूंगा आप उसके हिसाब से चलिए. I'll plan it. For example, before 31st of December, I'll take 4-5 themes, lectures, heavy lectures, apart from these Saturdays where I'll focus only on heavy topics. AI, I need 4 hours. Machine learning, generative, parametric, फिर AI application, AI regulation, AI ethics, 4 घंटे चाहिए. फिर I need time for energy transition. एक बार समझ में आ गया तो आप मेंस का आपके ना जनरल स्टडीज पेपर 3 के you'd be able to attempt a good number of questions. Like disaster management I'll take, it's a static part, I'll still take in class. So I'll give you a framework how to attempt those questions. I'm even attempting the static areas. Is it fine? Let's start the class. Start it. Any doubts that you have, by the way? The best is left. The court is opening up. It's done a big thing. Court has done Mr. Satyendra Jain, thanks to the Pankaj Bansal case. Pankaj Bansal was the owner of M3M group, and he got bail in 23 where Supreme Court had changed the framework of these sections which are beautiful, very interesting. Okay. Agreed? Right. Should I start? Now, this is the point. I was discussing what? Isme there is something interesting. What is interesting? These are twin conditions of bail, but even those conditions have got exceptions. What are these exceptions? What are the exceptions to these twin conditions? बताइए क्या एक्सेप्शन होंगी? एक, जहां अभियोगी महिला हो, women, you will give them bail. Stringent conditions will not be imposed. Twin conditions have got exception. और 16 वर्ष का बच्चा हो, पर वो बच्चा नहीं फिर बुद्धिमत्ता का बेहतरीन उदाहरण है. अगर 16 साल से कम का बच्चा प्रोसीड्स ऑफ क्राइम जनरेट कर रहा है तो फिर तो उसको सिविल सर्विसेज की तैयारी करनी चाहिए. वो तो बहुत ही आगे है, पावल डुरोव टाइप्स. सो ही विल बी गिवन अ बेल. और इट केम अप इन द न्यूज़पेपर 2 days back. A person was given bail because of this reason. Hindu 10th 11th page top right. If he is sick or infirm. Sick or infirm means बीमार हो. Something like Mr. G.N. Sai Baba. He got arrested under UAPA is replica of PMLA. UAPA is much more dangerous. For how many years? 10 years. Kept where? No. Mr. G.N. Sai Baba is on wheelchair. I'm not justifying him, just trying to give you a feel. Kept in Nagpur Central Jail. And in Nagpur Central Jail, kept where? In an air-conditioned room where he could attend all the live classes. He was kept in an anda cell. Anda is egg. It is an egg-shaped cell for solitary confinement. He was kept for 10 years. That is the effect of these conditions. It is impossible for a person to get a bail under UAPA and this law, because I'm telling you, there's a drastic change which I'll just tell you. which has happened in the jurisprudence because of the Supreme Court judgments. Right? So sick or infirm, and there is one more exception. If the laundering which has happened, money laundering which has happened, it is less than 1 crore. These are the exceptions. This is the law. These are the provisions which I have discussed with you. Is it clear? Now let's come to a new page. We'll draw a table, and I'd like to show you what? I'd like to show you the transition. Because all these provisions, they were questioned before the Supreme Court in 2022 case, and they were all upheld. 2022. It is called as Vijay Madanlal Chaudhary case. And there is one more thing which I'll study now. That is the transition. So on the left, we'll first write down. On the left, we'll first write down the Vijay Madanlal Chaudhary case. You can write Vijay Madanlal Chaudhary versus UOI 2002, or you can simply write Vijay Madanlal case, and you can also write on the other side the recent Supreme Court judgments. Because what is the point? I would like to make you feel this transition. Right? Now, let's start with Vijay Madanlal. Write down number 1 in 2022. In 2022, the Supreme Court ruled. 2022, Supreme Court ruled. In this case, basically, Supreme Court ruled what? Number 1. Money laundering is a heinous offense. Is a heinous offense, which is equivalent to terrorism. Start was amazing. We kept on saying draconian powers to ED, draconian law. No. Court said, what are you doing? It's a law that is equivalent to terrorism. So, number 1, this was a spirit. Number 2, you will write in the same discussion. Number 2, upheld the powers of ED of search, seizure, and summon. ठीक है? Upheld the powers. Then comes the most interesting part regarding the power to arrest. Regarding the power to arrest, गिरफ्तार करने की power. What is power to arrest? Section 19. If the ED has reasons to believe based on material in possession that the accused is guilty of the offense, then the person can be arrested. This was the power to arrest, high bar. And I told you, when the person is arrested, the ED has got a provision of filing FIR, no, ECIR, which doesn't get the powers by the law. So we said that, argued against the law. What are you doing? You are not giving the person ECIR. You are not giving him the grounds despite the law telling the person's grounds to be told. How can you not tell the person the grounds and you're arresting him? It violates Article 22. Am I right? You arrest a person, you are depriving his right to life, and you are not giving him the grounds. So in this particular case, the Supreme Court, number 1, said that ECIR should not be shared. Enforcement case information report should not be shared because ED is not police organization. ED is not police. एक तो पुलिस नहीं है, and there are sufficient safeguards under the law. एक तो sufficient law में safeguards हैं, कोर्ट के पास पावर्स हैं, you go to the special court that has been formed. And second, it said, I'll write it here. Second, it said that yes, grounds of arrest should be informed. Ground of arrest should be informed is there in the law also. Ground of arrest should be informed is there in the PMLA. But what used to happen? होता क्या होगा? What used to happen? So when the ED was arresting a person and they did not tell him, these are the grounds, let's meet in the court for bail. Those were verbally informed. मौखिक तौर पे बता देते थे in front of the ED's lawyer, and the person was made to sign that I got to know the grounds. So in a way they were implementing the clause but also not implementing the clause. And when the person has got nothing in hand, how will he go to the court of law and file a bail? Your lawyer will first tell the police, give me FIR copy, फिर देखते हैं है क्या. Let's read the FIR. Then we'll build upon a case. यहाँ पे there is no ECIR, which is not backed up by law, not given. Supreme Court said no. And then second, the grounds of arrest should be communicated, but did not open up the depth. Then change the flavor where we had the change in Pankaj Bansal case versus UOI 2023. This is a very important case. Pankaj Bansal versus UOI. Here the court said, number one, give him the ECIR. Yes, in the recent judgments ahead of the arrest clause, right ahead of the arrest clause. Court said what? Give him a copy of ECIR. Second, grounds should be given in written. If you are arresting me, you will give me grounds in written. I can tell my lawyer, now look into it, develop a case, explain to ED and the courts that, there's no trail of money that's involved. Not only this, when Mr. Kejriwal was given bail, I will not give you the name of that case. We will not write in the Arvind Kejriwal case. We'll write this, that number 3, that the reasons to believe, remember, based on material in possession, the court has got reasons to believe that the accused is guilty. Police will arrest. Grounds you have to inform, ECIR you have to give it, and also you need to do what? You need to tell the reasons. And it is not stopping here. In that Arvind Kejriwal case, I'll write here, you write now in your notes, I'll write it here. The reasons to believe, they should be admissible in the court of law. Such has to be the quality of this reasons to believe. When I say reasons to believe, I imply that it should be of high threshold. ऐसा नहीं कुछ भी लिख के दे दिया. You give me an answer, ठीक है, okay, ले लो, evaluate, कर दिया. I promised evaluation, I am giving it to you. No. A detailed evaluation, I need to justify the answer writing of evaluation. Why did I cut your marks? What mistakes you made? What points you missed? What example you didn't write? What was your conclusion? You could have done this, you could have done that. So reasons to believe, now look at the beauty. First, Pankaj Bansal did what? Said that inform grounds. Here, Mr. Kejriwal's case, it said no. Reasons to believe bhi batao. And the beauty, Mr. Kejriwal said that you arrested me in 22-23. After 1 year, you produced material in the court of law. Aaj giraftar kar liya. Arrest me today. And then the material you are presenting in the court of law, you did after 1 year. So Mr. Kejriwal raised something very interesting, which will now be examined by the court of law. What is that? What is that? Write down, the Supreme Court shall examine. What? Anyone knows? Necessity of arrest. क्या गिरफ्तार करने की आवश्यकता थी? Was there any such need to arrest? Mr. Kejriwal said, चलो ग्राउंड्स दे दिए, सब दे दिया, मेरा ये क्वेश्चन नहीं है. उनके वकील ने कहा नहीं, मुझे ये बताओ. What was the need to arrest? When I was cooperating, what was the need to put me behind the bars? I'm accused. Ask me questions. Give me a summon. Though 7 summons got rejected, he did not go for on 7 occasions. So you give me a chance, I'll explain. And that is what Vijay Madanlal case had got no answers. So what we are now doing is, a Supreme Court bench will look into this question. You might see something great here also regarding arrest. So you arrest a person, then comes next. What is next is what? The right to bail. What is it? Right to bail. Under section 45, the burden of proof lies with the who? Accused. Mr. Vijay in the Supreme Court in the Vijay Madanlal case upheld the twin conditions. दोनों ही कंडीशंस विजय मदनलाल केस में अपहोल्ड करी गई. These conditions are right. You should be having high norm. Why? Because the law has safeguards. But when Mr. Manish Sisodia got released in August 2024, listen to me, you'll write only what I'm writing here on the board. That's your answer. But I'm giving you the background. When Mr. Manish Sisodia got released, in this case, Supreme Court said that these twin conditions can be relaxed. You can relax under 4 clauses under the law, right? Sick or infirm women, 16, 1 crore. But these conditions can be relaxed if the accused is under prolonged incarceration. जेल में रखा हुआ है and the trial has not completed. The trial has not completed. Sorry, no, not completed. Please correct it. Has not commenced. Has not commenced. So for 17 months you arrested him. But in the court of law, the trial is not starting. What is his problem? What is his fault? इनकी गलती, accused की गलती क्या है? या है? Is he involved? No. Supreme Court said, you write it below here, this point, Supreme Court said it upheld the right to speedy trial. Right to speedy trial, which is under Article 21, a right to life. Under Article 21, the right to life. This is the first win condition. When one of the legislators of Bharatiya Rashtriya Samiti wanted bail, Delhi High Court said no, she is a woman, but she is privileged. She should not be given a bail. There is no such condition. In the second case of bail, Supreme Court upheld the exception for women under Section 45. It upheld, it was already there. So when the court is saying the law is silent on what kind of female, you just release if she's a female. Isn't it? And one more thing, the last thing, the Supreme Court has applied Section 436A of the CRPC, which is now Section 479 of Bharatiya Nagrik Suraksha Sanhita. Do you know this section? Do you know this section or not? Where a person can be released on bail if what? Can be released on bail if half the sentence has been spent in jail or incarceration. Jail or incarceration. Is it clear? If half of the period was spent, that was applicable in CRPC, but when money laundering came, we were not sure. So this was upheld in Madanlal case also, Vijay Madanlal case. The same thing was upheld and the Supreme Court repeated that. But there is a catch. This is 436A of the IPC. And now it is 479 of BNSS. This clause will not be applicable when, write down, however, under 479 of BNSS, under 479 of BNSS, it will not be applicable if the accused or write down, if the individual has been accused of, if the individual has been accused of multiple offenses. Is it fine? Multiple offenses. Is it clear? This is what is the recent judgments of the Supreme Court. You can write down, therefore, in the recent judgments on the other side of the table, second half, therefore, in the recent times, the Supreme Court has upheld Article 21 and reiterated the constitutional principle the constitutional principle that bail is the rule. Bail is the rule and jail is the exception. Jail is the exception. It was actually opposite the way it was running. Jail was the rule, bail was exception. But court has said your all statutory provisions in the law, no matter how grave they'd be, they all will be applicable because they all are under the Constitution. Constitution is upholding right to life. Is it clear? Now the last part. Last part is very interesting. The role of ED. Class को enjoy करो और समझो चीजों को. Don't take stress. Syllabus coverage is my headache, and I'll plan the classes that you will not feel the burden. But you focus here. Don't feel lost. Be attentive. Even if you're not, at least pretend. ताकि मुझे लगे हाँ सब बढ़िया. ठीक है. अब क्या है role of ED. Now I am discussing the last part. Role of ED. I'll discuss the good points and then I'll discuss the bad points. Good points, nobody says. What are the good points? या कुछ भी अच्छा नहीं है. What are the good points? The objective was attaching the property. That is why we got a specific law. We got Fugitive Economic Offenders Act in 18, and that is what ED has done wonderfully. It has attached the properties where in India and abroad. That's the first thing. किया तो है. It has wonderfully attached the properties. We should give it to ED, isn't it? Second, coordinated with who? किसके साथ कोऑर्डिनेट करना है? मुजरिम के साथ. कोई नहीं, काम हो गया, पर अब बताओ कैसे करना है. Coordinated, give me the keyword. Exact term. Interpol, blue corner notice, red corner notice, Mehul Choksi, Nirav Modi, all because of ED. Lobbying was done. They professed it like anything, isn't it? So you write down Interpol and government agencies. Very good, your point that you're writing. Very good. FATF has given us a report card. What is that? Good, bad, outstanding. FATF has rated outstanding what? Our performance in addressing money laundering and counterfeit. Just write money laundering because counterfeit we don't want to enter. We'll enter internal security. Just write down addressing money laundering. In what? In mutual evaluation report. FATF is, evaluating all these countries on a timely basis. They'd like to see the performance, and this is all because of ED, isn't it? Isn't it? और कौन सी बॉडी इन्वेस्टिगेट कर ही रहा है? ईडी. मेन स्टैट्यूटरी लॉ इज योर प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट, राइट? थर्ड एंड फोर्थ, what has ED done? What has ED done? With intent that we had brought the money laundering act, don't you think we fulfilled it? With the intent that we had brought the money laundering act, PMLA, and we gave the powers, statutory powers to ED, don't you think we've been successful? Quite successful. And thereby I would say that ED has ensured economic stability, isn't it? And ensured strategic autonomy. Isn't it? You are able to speak at the platform in the world against terrorism, against narco trafficking, against terrorism, because you've been successful. You've taken actions. FATF has given the report. You've done wonderfully. You're outstanding. And without a stable country, how will Maldives, Sri Lanka, Pakistan exercise strategic autonomy when you don't have money? In fact, economic sovereignty leads to strategic sovereignty, strategic autonomy. अर्थव्यवस्था ही अगर ठोस नहीं है, और ये तो बहुत major globalization of crime has happened. So you need to have a stable body, a stable response. We've done that. We should be happy about that. But on the other side, there are some issues, and these issues I'll first classify. First, I'll talk about the organization. I'll talk about the organizational issues that ED has. What are the organizational issues? I'll discuss that later. Number one, there is lack of staff, and there is lack of training and capability, or you can say capacity building. What do you think? Thank you. Isn't it? And that's a need of the hour. The economic crimes are increasing like anything. Look at cryptos. And when we are penetrating, the economic literacy is happening. We are using more and more these websites for payments. So the possibility of concealing that money has further increased. The money is changing hands at such a pace because of globalization, because of you and me using internet, that we need to train them. Nahin? What do you think? Isn't it true? And that is the next point, that autonomy. Experts have said that autonomy has been compromised. Do you think autonomy has been compromised? How do you know this? Because of repeated extensions given to who? Given to who? ED director. How? By amending CVC Act in 2001. Remember? 2 to 5, 1 year at a time. Amending CVC Act 2001, which was against the spirit of Supreme Court judgment. 2021, against the spirit of 2021 Supreme Court judgment. It is called as common cause versus UOI. Supreme Court expressed its disaffection towards these extensions that was given to Mr. Sanjay Mishra. It was made 2 to 3, 3 to 4, 4 to 5, and then Supreme Court said no. The details of that case law is not important, by the way. It's just one thing that you want to write, that repeated extensions were given. It's like a carrot and stick policy. You want that person to toe the line, so you are saying that we will give you extension. That is what the experts pointed out. Whether it is good or bad, that's a different thing. But the experts say that independence will get compromised, and it is also against federalism, isn't it? Why? Why is it against federalism? Tell me. First, opposition is saying that the leaders of opposition political parties are being targeted. Isn't it? I don't know it's true or false. I'm just saying this is the accusation. What else? Have a thought quickly. I'm repeating it. I told you earlier. That is inherent in the law. Which we have discussed. The list of offences has increased from 6 to 30. 6 to 30, which goes against the spirit of what? Which goes against the spirit of what? Against the spirit of what? Against the spirit of the intent behind the law. Write down. Intent behind the law. Also the law was enacted under section 253. Section 253. Sorry, under Article 253. I'm so sorry. Section 1945 is in my head. Under Article 253. In bracket, center making law in the state list. Center making law in the state list. For what? For what? To implement international agreements. Implement international agreements. Implement international agreements. Write down also FATF has pointed the problem of shortage of public prosecutors. वकील बहुत कम है सरकारी. FATF, when it praised the performance of India, it also said that you're outstanding in your objective of addressing money laundering, but there's a concern that you need to have more lawyers. And one more thing, write down. Supreme Court has pointed out that in the past 10 years, $5,000 cases have been registered. But the conviction took place. Only for 40. 40. Right? Now, actually, newspapers, they are reporting the conviction rate is very low. But that is wrong. What is conviction rate? which have been proved. Number of individuals proved to be convicted under the court of law divided by the total number of people for which the judgment was given. But this is not the case, that your conviction rate is not less, but the pace of trial is slow. That leads to permanent incarceration until what we saw the Supreme Court has done. तो केस 4000 10,000 पिछले 10 साल में लिए, ऐसा नहीं सब खत्म हो गए और 40 को सजा मिली, नहीं, नहीं वो कह रहा, केसेस पेंडिंग चल रहे हैं पर सजा सिर्फ 40 को मिली है। भाई या तो लो कन्विक्शन तब होता है व्हेन द केसेस वुड हैव गॉट कंक्लूडेड एंड ओनली 40. दैट इज नॉट द केस दैट वी आर डिस्कसिंग, राइट? This is one strand, organizational issues. Next point, next strand of points, write down. We are just at the end, I'll start map, don't worry. I hope you're active. Write down next strand of points. Write down. Frequent amendments in the past. Frequent amendments in the past to PMLA 2002 has increased the scope of powers for ED. Has increased the scope of powers for ED. which has led to arbitrary usage. Which has led to arbitrary usage. Second point, unnecessary arrests. Unnecessary arrests. Number 3, lack of conclusion of trial. Lack of conclusion of trial. And prevention of bail. Prevention of bail in bracket under stringent statutory conditions. Stringent statutory conditions. And the last strand of the analysis, first was organizational, second is what you wrote. Yes.
Sir, in the case told Kejriwal and Minister Sodia, and one more case you told, the one with which bail. We don't have to write the name.
No, you would write only the name of Pankaj Bansal case. Okay, so basically I was discussing what with you. Now we'll, what was the last point? Yes, and then write down the last point in your notes, all of you. The last point, first was organizational, second was law got increased. Online ones, we were again started. First was organizational, second was stringent law, third write down the amendments to the PMLA. The amendments to the PMLA. The amendments to the PMLA 2002. Amendments to the PMLA 2002 were brought in the form of a money bill. In the form of a money bill, and these amendments violated the spirit of what? Violated the spirit of Article 110. The spirit of Article 110, and thereby curtailed the powers of Write down. What was the last point? Against the spirit of Article 110 and curtailed the powers of. किसकी powers curtail होंगी? Curtailed the powers of Rajya Sabha. Powers of Rajya Sabha and thereby affected federalism. ठीक है? Now this is all about ED. Let's conclude. What will you conclude? Federalism, when question is asking, do you agree? We will not get emotional. In polity, we got to stick by court observations or commissions. So I tell you something interesting. Write down. The Supreme Court has ruled, conclusion, and the Supreme Court has ruled that ED should function in a fair, transparent and not vindictive manner. What is vindictive? बदला, बदले की भावना से इन्वेस्टिगेशन नहीं करनी. सुप्रीम कोर्ट ऑब्जर्वेशन है, we can write. Also in Vijay Madanlal case, the Supreme Court ruled, beautiful observation. Conclusions are beautiful, grand, that the ED should consider, should बोला है, ED should, मतलब कर ले, please attend the class. Don't think about hunger. I request you. ED is saying, please, should consider, number 1, informing the public about the desirability. Informing the public about, just remove desirability, just write like this, inform the public about the scope of authority. The scope of authority on the website, comma, measures adopted by functionaries. Measures adopted by functionaries. And number 3, remedies available to the accused.